The homestead as a concept is simply saying you get a certain exemption. And that exemption, well, earlier today, we've been talking about it in the bankruptcy context, but it also applies outside of bankruptcy. And so if you have a homestead, then the dollar amount of that homestead is determined based on the exemption tables. So if you have equity in the house that is less than the exemption amount, then creditors can't possibly seize and sell your property. Now, that does not mean that a creditor who gets a judgment against you is prohibited from recording a lien against the property. Now, why does a creditor do that? Well, if you have equity that is below the exemption amount, the creditor is not going to be permitted to foreclose on the property and seize it. But they'll have that lien so that if in the future you ever decide, I think I'd like to refinance or maybe sell the property, well, then as part of that transaction, you're going to have to pay that lien off. So that's why a creditor might do that. But yes, the house is protected up to the exemption amount. You can't be thrown out on the streets if you lose in a civil action and the creditor gets a judgment against you. But the creditor, of course, is not without recourse. It can record that lien against the property. It can also enlist the services of the sheriff to garnish wages, levy funds out of your bank account. So just because the house is protected in the sense that you get to continue living there does not mean that the creditor is without recourse and that somehow you're completely insulated from any sort of consequences of that judgment. Now, if you file a bankruptcy, then under just the right circumstances, based on this idea of the exemption, you can avoid the lien. Now, this is a somewhat unusual usage of the word avoid. It means to render null and void, and generally you're only going to see this usage in law. So how is that done? Well, if you're in a bankruptcy and there are judgment liens against you, this doesn't apply to other liens. A judgment lien is a lien that's recorded by a creditor who got a judgment against you after filing a lawsuit against you in the California Superior Court. The creditor then can take that judgment lien, it's also sometimes referred to as a judicial lien, and record it in the county recorder's office in the county in which you live against the title of the property. Now, let's say, for argument's sake, you're in a Chapter 7. The same analysis really applies in the other chapters. Then you can avoid that judgment lien to the extent that it impairs your exemption. And this is going back to the bankruptcy code. There is a provision in the bankruptcy code that permits this in section 522 G and H, the two put together. So how does this work? Well, as a matter of fact, let me take a step back. It's actually 522 F. G and H are a little bit different. They have a different focus. So how does this work? Well, what we do is a little bit of arithmetic. We determine how much the lien impairs the exemption by taking the value of the lien plus the sum of all other liens against the property plus the value of the exemption that you could take if the house had no liens against it at all. And that sum is compared to the fair market value of the property. To the extent that it exceeds the fair market value of the property, to that extent, the exemption is impaired. And to that extent, in bankruptcy, you can remove the lien. Now, of course, that doesn't get rid of the underlying debt unless you get a discharge of that debt, but at least you can clear the title of that particular judgment lien. So exemptions do have a very real place in California. Now, what I've just described, by the way, of the lien avoidance is only in bankruptcy. That's not available outside of bankruptcy because it's a creature of the bankruptcy code, as I said, section 522F. So California does have the homestead protection. And if you're in bankruptcy, you also have the option of avoiding any judgment lien to the extent that it impairs your exemption.